Hello, my name is Peter Gray. Welcome to the November session of Writing Arborist Reports. We're lucky enough to have a guest speaker today. Anka Costin is going to present a talk on writing expert reports for court cases.
I'm going to say probably to start with a few words about myself. As you can see, I'm a barrister. I'm at Blackburn Chambers in Canberra, and my area of work does sometimes come across tree matters. I've actually had a hearing last week in a tree matter, but I do administrative law, employment, commercial litigation. So everything that I do, of course, is litigious, given I'm a barrister. So first of all, I want to thank, I don't know, Christine, if it's here, Christine Rempling, and of course you, Peter, for organizing everything and having the opportunity to talk to all of you. What I'm going to try to do today is to talk about expert reports in your area. But of course, if you do have any questions throughout my presentation, feel free to unmute yourself and come and ask me a question. Otherwise, I hope we will have time this afternoon and have a chat at the end and ask me other questions then and there. A couple of questions have already been sent through, and I'm going to respond them as I go throughout the presentation. All right, so having that said, we'll start our presentation today, which is, of course, about expert witness evidence. And one of the things that I like, it's a quote from a movie, and if you do know the movie, I'm happy again for you to jump in and tell me. It's, if my answers frighten you, then you should cease asking scary questions. And I think it's very appropriate for what we are doing here today, because you as experts have to answer a question usually put to you either by a solicitor or by a private person who wants to engage you in relation to a matter they may have in court. So and this one is from Pulp Fiction, just in case you're wondering. And it's, as I said, it's very appropriate for what we are trying to do tonight and what your role is in general. The overview of today's presentation. So I'm going to touch on a few things. So the first one is, what is an expert witness and why are they important in litigation? Complying with statutory obligation or common law in terms of when expert evidence is actually admitted in court. Practical tips of writing a report, and I think this, I hope so at least, would be the highlight of today's presentation, and I hope will be probably the more used, I hope, tips that you're going to get today. The extent to which solicitors should seek changes to expert reports, and for those of you who have given evidence in court or have been asked to provide expert witness reports by solicitors, you'll know that solicitors can't help themselves, which I think is good, to try to make changes to the reports that you write. Then the last point that we're going to talk is privilege claim over draft reports. So of course, I'm going to start with what is an expert and how can you tell whether you are an expert for the purposes of a matter. Probably the easier way to identify whether somebody is an expert is to look at their experience, to see what they have done in the past, whether they have knowledge in that particular area of law, or whether they have, or law, just because I'm used to always talk to lawyer, or whether they have a particular skill. So it's usually knowledge, skill, and experience. And if you do have all three of them, or at least two of them or so, you can call yourself an expert. You do have to have, usually, there's no clear number of years, how many years you should have worked in a particular area to call yourself an expert, but it's expected that you would have had a number of years at least where you have dealt with a variety of issues that come in that particular area. So if you do have, as I said, some of the attributes that I was talking earlier, you can call yourself an expert and be able to put yourself before the court and give evidence, because at the end of the day, that's the purpose of writing your reports, with the view that potentially one day this particular report will be heard in court. So one of the things, of course, we look, at least us as solicitors and barristers, when we brief experts, we look at a number of things. For example, the extent of experience. So the more experience a particular person has, the more appealing will be for a solicitor to brief the person to appear in court. The area of expertise, of course, they have to have the expertise in that particular area, because otherwise they are not experts in that matter. Specialized knowledge and skill, report writing skill. And that, of course, is one of the things that we're going to talk about today, and how you can write better reports. Up-to-date and most recent developments in their area of interest. Previous experience in court, and of course, if that particular expert witness had experience in court, it's always preferable, because you would expect that the witness will know how to deal with the questions from the court, how to interact with the judge or the tribunal member, again, depending on what jurisdiction you're going to appear in. I just want to put a caveat, which I haven't done when we started, is that I am aware that you are from different jurisdictions. I am in the ACT, and different jurisdictions have different courts or tribunals where matters relating trees are heard. So I'm not going to talk about any particular jurisdiction, because first of all, I'm not familiar with all of them, but secondly, will take us all afternoon just to talk about that. So this is an overview that can be applied by any of you, disregarding the jurisdiction you're in. Well known to court or peers. Of course, if you have an expert that comes regularly before the courts, and the courts know that particular person and value their experience and expertise, it's always a plus, at least for us, when we consider briefing an expert. And of course, the cost of having an expert is also an important point to be considered. The importance of experts in litigation. What I want to probably explain from the beginning, I'm sure that all of you, if not most of you, understand that principle, is that, and I'm aware that you probably, the visibility of my slide, especially when it has a small writing, is probably not very clear. One of the things that I want to draw your attention is that sometimes there's a misunderstanding in relation to who is the expert helping, why is the expert there? The expert from the beginning is there to assist the court, is not to assist the party. The expert needs to be independent. The expert is not going to, just because they are paid by a particular party, the expert cannot form a view that it's assisting the other party, which otherwise would be against the expert's views. So the expert always have to give expertise advice, which is independent and is not supporting one of the parties in the matter just because the party is paying them. So they must be truly independent. And that's a very important point I want to make from the beginning. So coming back to why we have experts and why are they so important for the court, is that they provide specialized technical, scientific knowledge, information that otherwise courts would not have. It is not common for lay people to understand, much about a tree, or how can you have a tree prune, or whether you are allowed to cut a tree in what circumstances, etc. So it's not expected that people would necessarily have that knowledge. So when you have the expert coming, the expert needs to come with that knowledge and provide it to the court for the court to form its own view how the law applies to that particular information. So it's the role of the expert is to assist the decision maker rather than make the decision, rather than form the final outcome. So the way I can see it, probably in a layer way, is that the expert comes with the technical knowledge. The court can very well understand what the factual part are in the matter, but also the court is there to apply the facts, the technical knowledge, and the law to form a view. It's not for the expert to form a view in that regard. The expert is only to assist with the technical, scientific part that the court otherwise would not have access to. The other way that in my area of work I prefer to deal with experts is if I do have the opportunity to have a meeting with the expert before the expert report is drafted. It doesn't mean, and I'm going to talk later in this presentation, that I'm going to try to influence the decision of the expert. Of course, I'm not allowed, and I would never do so. But nothing stops a solicitor to come and have such a discussion with the expert to understand where the matter is, whether there is any prospect of success based on what the expert says, because some matters can be made or break in a way by what the expert says. It might be one thing on the legally part of the matter, but when the expert comes and provides the expertise, it might change many pieces of that puzzle. So don't be surprised if solicitors will say, let's have a meeting with you before you actually provide the expert report. Then the second part of the job that the expert has is, of course, to draft the expert report. And as I said earlier, this report is to assist the court what the matter is, but also on many occasions, it guides in a way the other side to understand what the case is put forward by the party that the expert represents. And sometimes this particular opinion from the expert can play a very important role whether the matter settles or not, or the matter otherwise goes to litigation. Then the last part of the involvement of an expert is the subsequent conference or conferences before the matter goes to a hearing. And again, in my area of law, I do have a preference to make sure I do meet my experts, especially if I didn't have the chance to meet them at the preliminary steps of the matter, to have the opportunity to meet with them before they give evidence in court. And if some of you haven't had the opportunity yet to give evidence in court, you have to understand there's a particular process and there's a particular way of giving evidence. So it's always recommended, and if your solicitor doesn't, necessarily engage with you to meet with them, my view would be don't be afraid to ask for a meeting, at least for a very short one, where you can ask the very basic question: how is the system in this particular court or tribunal? When do I speak? How do I answer questions? What do I have to do? How does it work? Because you always want your expert to be in the best position they can be in court. And of course, having some preparation in advance always helps. As I said earlier, you as an expert cannot be influenced by the view of the solicitor or your client. You'll never be influenced by them or the way you present the matter in court. But these preliminary conferences will be purely on what happens in court, what are the issues, how am I going to present myself, and sometimes it's even to have an understanding what are the issues in dispute, if some of the issues have resolved since you have provided your expert report. So there are a number of issues that could change throughout a proceeding. So it's always recommendable, if you do have the chance, have these meetings with your the person who's briefing you. Could be, as I said, a lay person, your client, or could be a solicitor. Again, because I'm aware we are in different jurisdictions, and again, it varies from state level to federal level, but in any event, most of the jurisdictions will have an expert witness code of conduct. And some of them will also have practice notes. These particular codes, as it says here, are applicable in each court or tribunal. For example, in the ACT, our expert witness code of conduct no longer exists from sometimes last year, but definitely they are in other courts and jurisdiction. Of course, we have them in the Supreme Court here in the ACT, and I think that also in Land and Environment Court. I haven't done a matter there for quite a while, so I can't recall precisely, but there's a good chance that you'd have expert witness code of conduct and practice notes. It's very, very unusual to have practice notes without an expert witness. Usually they go hand in hand. The reason I'm mentioning them is because you as an expert have to make sure comply with these particular codes and practice notes when you draft your report. I'm going to talk a little bit about law here, but I'll try to be brief. And I know that, even, people like my husband, who's not a lawyer, gets very bored when I talk about law. So I'll try to be brief on that. But the reason I have kept this legal part in my presentation is because if you have at least an idea where you should look for how the courts have previously decided expert reports or how they've looked at expert reports, I think will be of assistance to you. You just have to understand the basic principles of why your evidence has to be expressed in a particular way before the court. And I'll take you through all the rules and what the legislation says. So hopefully I can make it as clear as possible. So first of all, we have the statutory rules, which comes under a piece of legislation. And we have the Evidence Act, which is at Australian level, at federal, and of course we have in every jurisdiction, it's an Evidence Act that is very similar to one at federal level. So there's not many differences between the two of them. So one of the things that this particular information is important, and I'll come and discuss a bit in more detail, is the Section 76 of the Evidence Act, which is the opinion rule, which it says that evidence of an opinion is not admissible to prove the existence of a fact about the existence of which the opinion is expressed. I know it sounds very convoluted because it, even for some of the lawyers, it sounds very convoluted, but what actually this particular section of the Act says is just because somebody expresses an opinion, and this is not about experts, it's just about lay people in general, just because somebody expresses an opinion, it doesn't mean that it proves that that particular fact actually happened. So just because somebody comes and says, gives evidence, my neighbor cut his tree in the backyard, which was a regulated tree yesterday, it may or may not be true. And again, there are the different rules of under the Evidence Act, how we go about it. But as a general view, just because somebody says something, it doesn't necessarily mean it is true. However, this particular rule has an exception, and that's the exception that is relevant to you as experts. And the exception is in Section 79, which it says, if a person has specialized knowledge, just as I was talking earlier, based on the person's training, study, or experience, so that's very important, that's why I put them in bold, training, study, or experience, the opinion rule does not apply to the evidence of the put before the person. So basically, this is an exception to the section I showed you a moment ago. But the exception only arises if the person that expresses that opinion is a person who has specialized knowledge, and the knowledge is based on the person training, study, or experience, and is completely or substantially based on that knowledge. So even you as an expert doesn't mean that, for example, if you are an arborist, of course you can profess an opinion about trees in a matter, but it doesn't mean that you can profess an opinion about something that's completely unrelated to that matter. You do have to have this qualification, which is training, study, or experience, and your opinion has to be based on that knowledge. And that's probably, beside the tips that I'm going to give you today, probably the most important part of the presentation today. Once you understand how this works, you are already ahead of everybody else. So then I'm going to be very brief on that, is the legislation, or better said, the cases that have been decided before the courts, have talked about what knowledge means, because as I was saying earlier, the knowledge needs to be substantially based, or the opinion needs to be substantially based on that knowledge. And what knowledge means, and it can't be just a subjective belief or unsupported speculation. It also has to be, it has to be based on the facts, truth or principle, or from study or investigation. That's how you need to approach your work from that perspective. And the foundation of the witness knowledge, namely, it needs to be based, and that's exactly or similar to what the section says, based on the person training, study, or experience. And the other parts of authorities that I'm providing here, and again, I'm going to be probably brief, is that in HD and the Queen, which is a criminal law matters, which was decided in the High Court in 1999, explains what Section 79 means, which requires attention to the requirements of form by directing attention to whether an opinion is wholly or substantially based on specialized knowledge, based on training, study, or experience. The section requires that the opinion is presented in a form which makes possible to answer the question. So the next layer of your report is, once you have ticked the boxes that you have the study, knowledge, and experience, that the opinion is based wholly or substantially on this particular knowledge, The next part is that you need to answer the actual question that's before the court, and the answer before the court is the issues that are in that matter. I just see that Christine has her hand up, so I'm happy to take a question from her.
Thanks, Anka. I was wondering if I'm an expert giving evidence and it goes unchallenged and I'm wrong, do they have to believe me?
Well, this is a difficult part because it's very unlikely that somebody comes before the court and they put themselves as experts. And I assume that what you're asking me, that it's unintended wrong opinion, isn't it? That's what you're trying to
Yeah, like I'm thinking if we had one or
not intentionally,
like 150-year-old arborists declaring that copper nails kill trees, which they don't, but it goes unchallenged and both experts are agreeing and says, yes, copper nails in trees kills trees. Does that mean, does that just get accepted?
Well, the court, for example, let's assume, and that's probably, I'm trying to give an easy answer for a complex question. If the court would not have any submissions made on that, and I would assume that at least some solicitors will be there, or at least the other party, even if it's not represented, would have some knowledge. And I assume that because it's a litigious matter, there will be some dispute. One party would say that it causes damage, one party would say that it doesn't. I would assume that the court would hear from the other side. But the general rule of thumb is that if you don't have an opinion that is, and I can see that there's another question coming up, and probably the best way is if you, and Peter, I'll ask you to probably monitor the questions because I can't see everybody on my screen.
So why I ask, Anka, is because there's a lot of misinformation and myth about trees that's still getting circulated as fact in our industry because we're largely quite unregulated. So that's where my question's coming from.
Yeah, I mean, in general, again, without talking about trees in particular, if there's an expert who comes and has the credentials of an expert, as I said, based on knowledge, skill, etc., and the court forms the view that the expert can put forward an opinion about that particular issue in the matter, it's not challenged by any party, either by this, even at the solicitor level, not as an expert. The court, unless the court thinks that that's completely a ludicrous proposition, the court in principle has to look at it and say, well, if this is what the expert says and it's valid, I will make that decision. Of course, it could be that if something that sounds so ludicrous, the court will look at it and say, look, it makes no sense. But if it's something extremely technical that no lawyer can make up that view, or the court can't make the view, and the expert comes and says, you know, the sky is blue today, and there's no other way of the court identifying whether the person is right or wrong, the court is left with that particular evidence and has to take it on face value. Because that's the whole reason I was saying earlier, you as experts have to come with the technical knowledge that neither the court nor the solicitors have and can't, and even if we do, let's assume that we have some knowledge that we come across purely by doing, you know, lots of matters in a particular area of law. We will never be able to put opinions before the court that will have the same value as an expert's opinion, because we are the solicitors, barristers. We will never be the expert. The court will never take us at an expert level. We can make submissions on how the court should interpret the law or that, you know, a particular piece of information, but we can't profess that we have that knowledge. So that's why the experts are the ones that come with that knowledge. Yes.
Can I make a comment? So I'm aware of some instances where experts have given evidence in court cases, and in my opinion, they've got it wrong. And so the court makes silly decisions that we think are not good. And I think that I get the feeling that is what the question is going to.
Yeah, and I understand. And as I said, if it's non-challenge and it's an area that nobody can form a view except the expert, the court is left with no other information except what that particular expert has said. I personally have not come across a situation like this, to be honest.
So Mick
but
is asking a question: can a court request additional experts? And I think this is probably a good place to answer that question.
So it's again, and I'm not sure of everybody's level of understanding how litigation works, but in very simple terms, each party is entitled to bring their own experts. There are matters where the court, and I'm not sure if an arborist matter would be the case, or a tree matter, but there are matters where the court would say, each of you have picked your own experts, but we're going to do what we call in law hot tubbing, meaning that we put all the experts, how many they are in that particular field, they all have to be from the same field, and they have to provide a joint report, and then they will give evidence jointly, meaning that all parties will have the opportunity to cross-examine the witnesses put forward by either party. But I haven't come across a matter, and I doubt that the courts would ever have the opportunity to say, wait a minute, I'm not happy with this, I'm going to ask an expert to come and give evidence. There are situations, but again, this is not related to your area, where there's a coronial inquest. So it happens many times when you have a coronial inquest that the coroner can bring their own experts, which is basically briefed, obviously, together with the coroner and the coroner's assisting, whoever assists the coroner on that matter, but the parties still have their own witnesses. So it's not, the court can't create the case for the parties. The court is bound to deal with what's put before the court in terms of evidence. And if the evidence is not good, as I said earlier, the court doesn't have usually the capacity to understand whether that evidence is right or wrong. I see that we have Adam with a question as well.
I just wanted to add to that. If you're an expert witness for one party, and are you expected to have an answer to every question that is raised on the day? For example, if Mark was on the other party and he somehow convinced the court or convinced the jury that the nail does cause damage to the tree, and I just couldn't say otherwise because Mark, is a lot smarter than I am, would somebody get another chance to go back and gather the research, or are you expected to conclude on that then?
No. So the way it works is that, as I said, each party, how many parties there, usually there are two, but it could be more than that, they can get their expert evidence. They have the time, there's a particular time frame for each party to put their evidence. And of course, usually the applicant puts their evidence first, the respondents put their evidence after that, and then the applicant has another go to put evidence in reply. These are the only chances that the expert can put their, it could be the report, could be a witness statement, affidavit, could be different ways evidence is given in court. Usually my preferred way is to have an expert report, an actual report written. So these are the only chances for you as the expert to put your best foot forward, where you say in that written document what the case is about and what your opinion is. It's very likely that your opinion will be very different to the opinion expressed by the other side, because that's why you are in litigation. Otherwise, the matter would have resolved before reaching the court.
Anka, could we hear from Mark? I see Mark would like to say something.
Yeah, I think you've been answering the question brilliantly, and I'm enjoying it immensely. But look, essentially you have the chance to give evidence, and if you fail to take that chance as a plaintiff or a defendant or a respondent, an applicant or whatever it might be in the jurisdiction, then that's your failure.
That's right.
The one exception that we deal with, Christine, in New South Wales fairly regularly, and this is the Land Environment Court, where the Land Environment Court actually appoints an expert, often as a commissioner.
Yes, that's right. There's a commissioner, but they're not necessarily experts per se. They are there to decide the case.
Yes, but they can introduce their own evidence, and I know that Chief Justice Prestons did a wonderful paper on that very issue about 4 or 5 years ago.
Look, I'm not disputing that, because as I said, I've done one a long time ago, and it did come before the commission and it eventually was resolved. But, and again, I'm talking from more from the ACD jurisdiction in terms of how it works. I'm not familiar with that, and I won't say whether it's right or wrong. But as a general token is that you do miss your opportunity if you haven't put in writing that particular information. That's in usually, as we call it, the evidence in chief. Depends again on the jurisdiction. You still have the opportunity to give evidence in chief, but you cannot come in your evidence in chief with completely new concepts, completely new ideas that you did not foreshadow at a time of writing the report. Then coming again to Adam's question, you will have to answer questions. And of course, usually in cross-examination by the other side, all sorts of questions that you might not even have thought of, depends on what's there. And the court would expect that you as an expert have an opinion. It's not again expected that your opinion will be identical to the one expressed by the other side. It may be some situation where certain parts of the matter you agree on, but I'm sure there will be many that you don't agree on, because I said that's why the matter has ended up in a court of law. Otherwise, the matter would have settled long before that. So don't be afraid, and that's my advice, don't be afraid to put your view the way you think is best before the court. Because at the end of the day, you are an expert. You can stand on your 2 feet and express, this is my view because I have this particular skill, knowledge, and experience in this particular area. If it differs to the one presented by your counterpart, it's not relevant. The court will be in a position to pick and choose which one of the two of you, let's assume, is more credible, and it makes more sense. The evidence is logical. It ties up perfectly with the case that's put before the court, etc. You as an expert have a very important role in a matter where the case lies almost entirely on the evidence provided by the expert. But even if you have this in mind and you think, oh, my opinion is so important, I don't want to say something that's not right. On the same token, don't be afraid to advocate in a way, probably is not the right word, but to put your position forward as you think it's best.
Can I just raise the point that I think in talking about one side or the other side, we need to emphasise that an expert witness is independent and is supposed to be giving unbiased evidence.
Correct. And that's what I said when we started. That's right. 100%. So, but on the same token, you do receive a brief of material that's provided to you by one party, and it very well be that your opinion, if you don't have the full information before you, may be influenced by the documents that you have before you. But without a doubt, and that's exactly how I started the discussion today, is that you must be independent and form a view that it's for the assistance of the courts, not the assistance of your client. If it falls on squarely to assist your client, mine as well, but you should not be influenced by that.
Anka, I think we've canvassed this sort of area pretty thoroughly. Can we move on with your presentation? And if we have time, we can come back to
I was just looking at the time now, and I'm becoming a bit aware that we might not get there. So another case that is very important, again, if you do have free time and you feel like reading a bit of law, this is another case that I would recommend. It's Makita, which the main points that you should take from this case is that the requirements is for you to be an expert is that field of expertise or experience, as I said earlier, facts the expert considers to be the relevant ones, the theories, approaches the experts consider to be appropriate to assessing the relevant facts, the opinion the expert arrives at after applying the theory to the facts. But I'm going to talk a bit about the last part of that. Another case, and I'm not going to read what it says, but it's Das Riff and Hauchar, which is again a high court decision, and it's about it's quite an interesting case about a gentleman, Hauchar, that was employed by Das Riff for a long time and developed silicosis in his lungs, and the question was whether the expert that Mr. Das Riff called before the court could actually profess a particular opinion that the expert did. And also it was a question whether the test that the expert conducted were relevant in this case and how he had reached that particular opinion. And that's, as I said, in a second, I'm going to talk about this point because it's another important point in your interest as experts. And this is one of the rules, which is again found in Das Riff. And the only bit I'm going to read is that an expert opinion is not admissible unless evidence has been or will be admitted, whether from the expert or from some other source, which is capable of supporting findings of fact which are sufficiently similar to the factual assumption on which the opinion was stated to be based to render the opinion of value. And one of the, and I think the next one is the one I was talking, the statement of reasoning. There is no doubt that an expert opinion is inadmissible unless the expert states in chief, and that's what I'm talking about, chief evidence, and usually it's the report that you write. The reasoning by which the expert's conclusion arrived at flows from the fact proved or assumed by the expert, so as to reveal that the opinion is based on the expertise. And I'm going to stop here for a second. The reason this is important is because I read many reports where the expert comes and professes an opinion, but never explains how that opinion was reached. In court, and especially if you have somebody on the other side that has a particular interest in expert reports, for example, can even make an application to the court to say, strike out this report because it doesn't comply with the rules in Das Riff or Makita, which are common law rules. And it can be that the court may say, well, you're actually right, because the expert comes and says certain things that the expert wants me to take as on face value, but I don't understand how this process works for the expert to reach a particular opinion. So one of the things that I stress for you as experts to remember is that when you form a view, you need to explain how you reach that particular opinion. It could be through testing, it could be through visual observation, it could be based on particular books or peer review that you have read. It could be a number of these put together that you also saw, but you also conducted a number of tests, and this is what you drew as a conclusion, or you've made certain calculation in relation to the that particular tree, for example, or measurements. You need to put this clearly in your report, because if you don't, and you just come, for example, you have a question whether a tree is a protected tree, it's a or not, for example, and you don't explain, you just answer yes, for example. Not that I assume it would happen, but talking about the extreme case, the court will say, well, why? How did you reach this conclusion? And as we discussed earlier, you might have already missed the opportunity to tell the court how you have reached that conclusion. And as I said, if you have somebody on the other side that says, well, this shouldn't be admitted into evidence, it causes a lot of problem for your client to try to bring the expert report back into court, to be allowed into court, or maybe, as I said, some parts of your report will be struck out. And if that's the case, it's very damaging to your client, especially, as I said earlier, if you have a case where the case itself, the outcome, hangs heavily on what you say on your report. So always have that in mind. Explain in your report how you reach your conclusion. And now I'm going to talk about...
Is it safe to rely on the solicitor who's engaged you to pull you up on that?
Look,
to say how
it
did you form
depends.
this particular...
Look, it depends on, of course, each solicitor. You could have a solicitor that's very experienced in a particular area of law, some that don't, some that are new in the profession. Who knows? My view is never rely on your solicitor, especially if you have the opportunity like you do now to talk to me about how to write best expert reports. Always have in the back of your mind, how am I going to do it? You as an expert are expected to understand that you need to have certain information in terms of how to write an expert report. Yes, you can have a solicitor that could say, well, can you please explain this in more detail, or can you do this and the other? But it might be that is not the case, and then you are the one who's responsible for what you write. And as I said, I'm going to talk shortly about what you should expect from a solicitor and what you shouldn't expect or should not allow from a solicitor or a client, mine as well, to come and tell you how to do your report. So I'm just going to give you these tips and then I'm going to talk about this topic. So the reason I'm saying this is because set up your report as a similar to an affidavit. And I don't know how familiar you are with affidavits, but the idea in an affidavit is that every paragraph is numbered. Of course, you have number pages, etc. You have headings and subheadings, but each paragraph should contain one idea only. So if you talk about the root system of a tree, talk about in that subheading, and then every idea that you have about that particular root system to be in a paragraph. And also one of the things that I like is to have white space in between paragraphs, because it makes it a lot easier for the court to read and probably make notes and so on. But try to structure it as an affidavit. Paragraph number, one idea for each paragraph number. Then, as a matter of background, and when you draft your report, always put the outline of the matter. What is this matter about? It's not a bad idea to also outline the documents that you've been provided with, so everybody understands what were the documents that you reviewed when you formed that particular opinion. And that's something you can do it either at the end of your document or in the beginning. Then you have to make sure, and that doesn't have to be in the report, or it can very well be, that you understand why you have been asked to provide that particular report. You need to understand the nature of the dispute. You can very well say, this report is in relation to X, Y, and Z. So everybody again understands what is your view in relation to what you have to provide to the court. So you make it very clear, these are the facts, this is the document that I'm relying on, and this is the issue that I understand I have to talk about. Then you have to make sure you peruse all the documents that have been provided to you. Sometimes it happens that you look at certain documents and you say, well, they gave me that and the other, but I don't have the information about something else in the matter. And if you don't have the document and you think it's really important for your report, make sure you ask for it. There's no drama in that. Nothing will stop you to say, well, it appears that you had a report done 10 years ago, and it may show me how this particular tree has developed since then. Can I please have a copy? And if it's relevant, have a look at it. There's not a problem. And refer to it in your report. Then set out the factual basis or assumptions that you consider in your report. So it could be that there's a fact that the tree is located in the northeast of the property, whatever the case is. But then it may be that in relation to your report, you need to think of some assumptions. You need to have them based on some premise that it's something that you as an expert think is relevant to the court. You may very well say, well, if the tree was to be pruned to the northeast or whatever, this is how it would impact, for example, the property, the tree development, etc. It may very well not, this information might not be something that your solicitor or the person who briefs you have thought of, but nothing stops you to take it further and consider it. But the most important part is you make sure that you have provided in the report the assumption that you made. And you make it very clear this is an assumption. If things were to happen this way, this will be the result of that. Then the other practical tips is always address the alternatives. So it's a hypothetical situation I said earlier is different than an alternative, because an alternative is, if it's not A, it's B. But an hypothetical situation where you think of, well, it could be this, but the alternatives many times come from the other side. If you do have the opportunity to read the report from the other side, and you consider the alternative, but again, make sure you outline in your report that this is the alternative you consider. It's not something that you take on face value. If the opinion is based on a particular theory or on particular information that you've gathered from peer reviews or any books that you have read, make sure you outline how you have come to that particular theory, what it is based on, what documents you have read that you have reached a particular view. And again, it's a matter of explaining very clearly to the court how you have reached the opinion. Again, this I'm stressing on this. Don't just profess an opinion because you think I'm the expert, I can say whatever I want. Your expert opinion has no value if you do not explain how it works, because then it leaves open all sorts of interpretations, and also it does not comply with what is required of you as an expert. Comment on opinions expressed by the other experts in proceedings. If you are, of course, for the plaintiff applicant, you won't have any other experts in the matter initially when you write your first report, but you will have them when you can very well write a report in reply. Because as I said, the first one has the opportunity to put an answer at the end. If you are for the respondent or defendant, of course, if there is an expert on the other side, make sure you read that particular report or reports, how many they are, and make sure you address them in your report. Never forget about that. And if your solicitor hasn't sent you any, make sure that you ask for them and review them appropriately. So as I said, if you are for the party that commences proceedings, you might not have them to start with, but you definitely have them in reply. So make sure if for example, if your solicitor provides you with the report later on in reply, and the solicitor says, look, don't worry about giving an expert report in reply, have a think about it. It may very well not be the case, and the solicitor may be right. But if you think otherwise, make sure you tell your solicitor. It doesn't mean that you have to write a report if the solicitor says, don't worry, I don't want you to write another one, because obviously the solicitor is not going to pay for that. But if you think that there should be a reply, again, make sure your solicitor knows of your view. Always make sure you comply with a time frame. Again, as I know solicitors, many times they brief experts right at the end. So be aware that they will always be in a rush. Again, if you have the opportunity and you have sufficient time available to you, send the report in draft to your legal team. And I'm going to talk now about how it works with the draft. So the legal team, whether there's a solicitor or just the client that is not represented, is entitled to see a draft report without a doubt, and is entitled to ask you questions in relation to your report. But what they are not entitled to do is to change your opinion or to try to influence your opinion in any material, substantial way. For example, the solicitor can say, well, you haven't put paragraphs, for example, or you haven't put any subheadings, and I think it will work well for the court if there are some headings here, because it makes very clear what this paragraph is about. Or I can see you said this about this particular issue, but you haven't explained how you reached this particular conclusion. So all this feedback, the party that's briefing you is entitled to give you. But what the party can't do is to come and say, well, you said that I should cut the tree, but my view is that this tree should stay. How can you have this view? And I'm not happy with your report. I'm not going to pay you until you say the other way. Of course, this is unpermissible. Never agree with something like that to happen, because they're not allowed to do that. As I said, they can ask you anything that's about even the substance of your report and ask you a question and say, well, maybe you should address this because I think the court will be interested in your view in particular about this particular point of view, or you haven't answered question 3 of the briefing letter, or you haven't answered it fully. All this absolutely fine for you to be guided by your instructors, but you can't be guided, as I said, anything substantial. And I hope this is very clear, because it's a very important part, I think, of your report. And I come across this question all the time: how far can somebody make comments to a draft report? Well, as long as they don't change any part of the substantial report. And I think I hope that's very clear for everybody. All right, coming back. So as I said, paragraphs, headings, page number, everything always assist. And the reason is assisting is because when you are in court, it's a lot easier for the court and the legal profession to address you either in cross-examination or examination in chief on particular paragraph, rather than say the paragraph in the middle of page that is not numbered, Your Honor, but I've taken the steps to number this report just to assist the court or anything like that. It just feels a bit clunky, and it just disrupts the flow of court proceedings. So always make sure that it's the whole point is to have very easy access to your report, and everybody should look very quickly and say, yep, that's the part I'm interested in, that's what I'm going to talk about. Provide your CV or outline of your training and experience. Usually, again, my preferred way is if it's an annexure to your report. Of course, it may be with other annexures, but make sure you have a CV, or at least if you don't have a current CV, which of course the CV should always be current. If you don't have one, make sure it's in the first part of your report, or at the end you explain what your experience is, and always put, you know, where you've worked, where you are currently working, what training you have, what licenses you hold, whether they are current, what registrations, everything like that, that would give the court confidence that you are still in this particular area and you are very current with everything that's happening there. And the part I was talking to you earlier is about the code of conduct. Many jurisdictions have a part where they say that the expert needs to explicitly include in their report that they understood the code and they agreed to be bound by it. And of course, to understand the code, you have to make sure you read the code or the practice note, understand what you need to do under it, and then say in your report, I have read that and I agree to be bound by it. Because sometimes, again, it's a requirement that your expert report can't be admitted to court if you haven't complied with this requirement. And that's probably, I'm not going to go too much into this because I was just touching how much the party that's briefing you can get involved. And as I said earlier, nothing in terms of substance, but it can very well do with the form of your report. It has to assure that the expert addresses every question in the briefing letter. If you do have a briefing letter, sometimes there is no briefing letter, especially if you are engaged by the client as a lay person. The report complies with the applicable code and practice note. And again, you have to bear in mind that the report needs to assist the court in relation to form of substance. And that's where, as I said earlier, the solicitor can come in and assist you in a way to make sure you write the report in a way that it's easy for the court to read, addresses all the issues that from a legal perspective sometimes are addressed, because again, we are all there to make sure we assist the court. Even us as legal professionals, our first and foremost duty is to the court rather than the client. The client is number two. So we all have the same point in mind. And then I'm going to talk very quickly on the privilege claim. And it has to do with legal privilege and how it works. And the gist, for example, of this case from Victoria is that the practitioner in conducting litigation, and that's of course, it's applicable to you as well because it will be the draft reports that you write, have to assume as a starting point that all communication with experts are likely to be discoverable document in a proceeding, and that the service of an expert report may result in the waiver of a client legal privilege over this document. So in other words, is whatever you write and when you exchange correspondence with the party that has engaged you, make sure that if those documents are ever to be produced to a court, is nothing that you'd be embarrassed of. And, you know, there are situations where sometimes other side or you know, sometimes even the parties within the same firm talk in a particular way about the other side. It's, you know, my view is never do it, because first of all, it's not courteous. Secondly, if the document is discoverable, you don't want to be embarrassed by any information written there. So the principle is always have in mind that if you produce something, it may very well be discoverable, and the other side would have their hands on and interpret it in however ways they think is best. And these are it's the common law test of legal privilege, and it's in relation to whether the matter has already commenced as a litigious matter, and whether the document that has been written by you as the expert is created for the dominant purpose of receiving legal advice or dealing with something related to litigation. So therefore, just bear in mind how it works. But this is more from a legal perspective, but it ties in with how you conduct yourself in when you exchange draft reports with the person who has briefed you. So I think we've reached the end, and we are here at question time, and I can see there have been Lots of questions in the chat, and I tried not to be disturbed and turn my eyes to it while I was trying to talk about different things. So, Peter, I'm more than happy for you to tell me which one are, from your perspective, the ones that I should answer to, or otherwise people can jump in and ask me questions.
So thank you, Anka. So Christine would like some clarification around whether or not there's a standard structure or layout for reviewing other expert reports. I think you've kind of answered that question, but if you perhaps could briefly address it.
Yeah, so the way I propose you do it, first of all, you look at their qualifications, because you as an expert will understand a lot better than a lawyer whether the person has the expertise. And if you think the person doesn't have the expertise in that particular area, make sure you bring it up with the person who's briefing you. So that's number one, because if they don't have the expertise, their report will never stand in court. Then, of course, always look at the proposition that they put as facts and mirror them with what you consider as relevant facts in the matter. Because sometimes, for example, some measurements don't match up. And you might look and say, well, I've conducted a measurement this way. I say this is the correct way of doing it, especially if the measurements, let's assume, it's an issue in your case. If they bear no relevance, you might not be so worried, but it might be that they are. So look at what the person has considered as facts, check them out. Then consider the premises or the assumptions they've made. And again, try to consider it from your perspective, whether the outcome of that assumption is correct. And if it's not correct, explain why it's not correct. And it may be, for example, that you conducted an assessment which is done in a different way. And the outcome could be the same or different. And you want to comment on that particular point.
So, Anka, you're talking about what should comprise the parts of your report, but I get the feeling that Christine's talking more about the layout.
The other side.
Is there
exactly.
a form that you should fit? My opinion would be there's not. You can do it however you like, just so long as you address those things.
Yeah, my understanding was that Christine wanted how she approaches the reports from the other side when she addresses them in her report. Is that correct, Christine?
How do I set it out in my report? Like the last one I did was just bullet points. Mr. Arborist said that the area was 12 meters by 7 meters. My measurements had 8 meters by 6 meters.
And that's a factual thing, as I was saying. You address the factual thing by comparing what the person said with your measurements. And that's absolutely fine.
As simple as a list of bullet points? Or do I
as long as it's easy, if it's easy to be as bullet points, fine. If it's something that you have to explain an assumption or a particular test that you've conducted, I mean, obviously it's a measurement, it's clear how that was conducted, there's not much about it. But if it's an assumption that you want to develop more, then put it as a heading, for example, or subheading with a paragraph number. But if it's just as simple as I've conducted the measurement, this is wrong, I have, especially if it's something that's very easily identifiable, there's not a problem with it. There's not a particular standard in any way. And even writing reports is not a particular standard. I have a preferred way of reading them, and it's similar to what I outlined earlier with background, making sure you understand what the point of discussion today is, etc., because they're easy to read. And then leave at the end, that's my preference, after you have outlined your version of the case, explain what the other side says about X, Y, and Z. There may be issues that, first of all, are not relevant and they're addressed by the other side. Don't worry about them because nobody will care. Or there are points that you agree. And again, if they're not bearing any importance in your case, again, don't worry. But if it's something that you want the court to know that both of you agree on a particular subject matter, make sure you do say that, because it would give the court the benefit of not wasting time on disputing or hearing on a particular issue, because both experts have the same view in relation to this particular measurement. Let's skip and go to the next one. So that's my way of dealing with it.
Thank you.
I can see Mark has a question as well.
Just more a comment back to Christine from mistakes that I've made, and I wrote it in the chat, is try and respond impartially, objectively, and as much aloofly as possible, rather than saying, Christine's made I'll give an opinion I disagree with. It can be expressed as gently as something like, "This has been suggested that. However, my opinion is," So you're not attacking the person. You're not seen to be attacking the person. You might not be doing it, but when you're expressing a different opinion as an expert, it can often come across the other party that's the case. And one of the things you definitely do want to get when you're working as an expert is you want to get along with the other side. You want to be able to sit down and have those discussions and have them, as much as you need to, open up and have the dialogue that sees you come to agreement where you can.
I mean, that of course, it depends on the preference that your team has, because there are litigious matters where they would absolutely hate any witnesses meeting and talking about the case. As I said, there are cases where the court encourages the parties, and I said the hot tubbing, where they say you need to get together and sort this out and provide me with a report that you both agree. These are the issues that we all agree. These are the issues in dispute, and this is how we think you should solve it. So it depends again on the jurisdiction you're in. And as I said, I can't tell you if this is one where the court would take this approach. But my view is definitely if you have a different opinion, laid out however you want to put it in whatever terms, but you need to make sure that you have a different view and you've looked at the report and you provide a particular comment.
Ryan would like to get a bit of clarification about what should go in a CV. So he's asking whether or not only the qualifications that are relevant to the industry should be included.
In principle, yes. It did happen in the past where I was it was a planning and environment matter, and I've heard that one of my experts, by chance, not because it was in his review, that used to be a builder 10 years before, and that was relevant to my case. But that's usually an unusual situation. In general, the court wants to know if you are, for example, an engineer and an arborist and also have some expertise in fire or whatever, that would be relevant to your case. But the fact that you might have been, I don't know, a teacher in a foreign country teaching a different language, the court would not care anymore. So that's completely irrelevant. So yeah, try to keep it to what is relevant to your case. And as I said, you might need to change the CV depending on a case, because in some cases it is relevant. You have expertise in fires and bushfires, etc. But in some cases it doesn't matter because that's not a issue in dispute.
So Adam would like to know about the minimum qualifications for expert witnesses, that AQF 8, and I think you have explained that earlier, but if you would just explain again briefly.
So what I've explained is in relation to general view, and not in particular to arborist, of course. And I'm not, as I said, I'm not going to say that I know everything about this area, and definitely I don't. So I'll just give you, as I said, a general overview. You do have to be able to be credible before the court. So as I said, there's no rule of thumb to say 5 years is sufficient, 3 years, because it depends. You might have 5 years, but out of 5, you've had done only 2 reports the entire time, or you might have 3 years, but you've done a report every week. So it depends on how much you actually know about a subject matter. And that's why it's hard to say. So as long as you have, as I said, the knowledge, the expertise, the experience and the training in that area, you can put yourself forward as an expert. But
Christine's got another interesting question.
Yes.
About the language in the report. So the difference between saying I observed or the author observed.
Yeah, look, my preference, again, and that's a matter of preference, and I don't think it makes a difference, is my preference is to speak at the first person, but it's not wrong if the person says the author, because it's understood that the author is the person who wrote the report. But it's if you put it in the first person, it just becomes more yourself, but there's no difference.
I think Mark would probably agree with me when I say that writing expert reports is quite different to writing arboriculture impact assessment reports or other reports that we write, where we use more formal, distant language, and we don't necessarily put ourselves forward in the way that we would for a court. But the court wants to hear our opinion.
That's right, and it's more out of convention, Peter, I think, than anything else. So when I was always taught that when you write as though you're writing a letter to the judge, communicate as if you're writing to him, because that's the way he wants to hear his evidence.
That's right. You are communicating with the judge, but again, if you call yourself I or the author, the judge is not going to get offended as long as the information is there. So either way, the court will have a very good understanding what it says. So I think it's just a preference rather than anything else.
Okay.
Do we have other questions?
I have another question, but I feel like I'm the question hog.
That's all right, Christina. I forgive you.
The last week when I was working with you on that matter, you had me remove a section where I quoted previous case law that I thought was relevant.
All right, I'll just have to make one point here. We're not going to talk about the case, first of all, because the case is not decided yet, and I would not want to. Obviously, I'm not referring to this case. It's just an example. So I just want to make it very clear, especially that this matter is recorded. I don't want to have a discussion about a particular case. But as a general view, my preference is, and again, that's my preference, and I think it would be endorsed by many lawyers, is that the case law in general is to be left for submissions for lawyers that put it before the court, because you come there before as an expert in your area. Anything that has to do with the law, it's a matter for the lawyers to do it. And whether they find a case, and even if you put a case that you know it's a good case, perfect, the lawyers can use it, but it's not a matter for you because you are not legally trained. And even if you were legally
So is
trained,
it like,
you attend as an expert, not as a lawyer.
so that was me sort of stepping out of my lane.
That's my view, yes. If you want
Okay.
to put legal cases, I would say to you, don't talk to your lawyer and say, I have this case that I know of. It's very good for our case. And the solicitor would say, thank you very much. I appreciate this. And I'll use it or not, depends on the solicitor's view of the case, but don't put in a report.
Okay, thanks.
Are there any more questions?
Oh, Tom here from Adelaide. Can I ask one?
Yes, of course, Tom.
I suppose, can the language I use in a report be challenged? So if I say a tree has good health, and I've got an explanation of what my interpretation of good health is,
Yep.
Could that still be challenged in court? Say, well, we don't think good means that, we think it means something else.
No, I doubt, because again, the court needs to look at what means in plain language. In a way, good health means the same thing for a tree, for a person, for an animal. Of course, it could be that you do need to qualify that, and you explain, I've looked at the trunk, I've looked at the leaves, I looked at the crown, this and the other, and I draw the view that it's in good health for this reason. Just like you look at the person, I've done the blood test, I've done the scans, I've done the imaging, and that's what I've came up with. And again, if you would just say, this tree is in good health, your opinion would have very little value in court, because the court will say, why do I believe you? Because you didn't tell me anything. But when you say, I observed this, I tested the other, I've looked at the I've looked at the leaves are green and, very little shedding of leaves, or whatever the case is, or sheds the normal amount of leaves for a tree of this type. Then the court will say, yep, I can understand why you're telling me it's a healthy tree. But if you just profess that you as an expert are of the view that's healthy, it's not sufficient. And it comes to right at the point I was talking to you about. Always lay the ground. Always explain to the court why you reach a particular view, how you have come to that conclusion. If you don't do that, and I said you come across a person that's on the other side that has a view of how expert reports to be written, and I'm not going to say that it might not be me, you might be in trouble, or your client, because that side may make very strong submissions to the court why your report or parts of it should not be admitted into evidence.
Okay, cool. Thank you.
Do we have any other questions? I can see Adam is back with another question.
Is the presentation just for more private lawsuits, or is it relevant to like a QCAT?
It's the same. So jurisdiction would expect the same level. So as I said earlier, in ACAT, we don't have a code of conduct, but it doesn't mean that you can go off and, as I said, put a view that the tree is healthy and say nothing about it. Because again, the court and the tribunal would have, and when I say court, I'm including tribunals as well, would have the same expectations of you as a superior court would have. It might not be held at the same level of imposing those requirements, but it's very unlikely that you can come up with a report that, as I said, doesn't comply with any of the rules, and you just say to the court, well, accept it because I say so. They will still have to look at it. It may be that in a lower court or in a tribunal, you may still manage to get that report into evidence. But what the other side will say to the court or tribunal, you should give very little weight to this document because it hasn't done this and the other, hasn't complied with any rules. And then even if you have a report that's in evidence, but the court says, well, it's pretty badly written, it doesn't help me, I'm not going to accept this, I'm not going to accept that, and I might not give a lot of weight to it, and then has a report that's perfectly written and say, well, I'm going to prefer that opinion because it gives more confidence as well. When you have a report that it's well written, there's no typos, it has page number, has paragraph, has subheading, it outlines the background, the premises that the report is based on, the outcome, the conclusion, the CV. You tick all these boxes. Of course, a court will say, I'm going to trust this person more because to start with, I can read it, I can understand it, it's professional, rather than have a report that's 2 pages and it's poorly written. And I'm sure we all have seen reports and I have in my other areas of law that I try to understand what the report is saying because I can't understand it. And that's if I can't understand it, the court will be in the same situation as me, and that will never help the case. And again, notwithstanding that you are not there to push the person that is briefing you to push their case, is not that, is that the court will say, well, I can't trust this expert, it's not helping me. And that's not what you want, of course, to achieve.
Thanks.
That's all right. Any other questions? Because I'm mindful of the time, so.
Yes, we've gone over our hour.
Yes, I know, and I'm happy to take another 1 or 2 questions and finish in probably 7:45 or so.
Yeah.
As I see there are quite a few in the chat, but I haven't followed them. So
I think in the chat, we've got a few answers to the questions, and I also think that some of the questions have been answered by a presentation. I think that, unless anybody feels that their chat question hasn't been sufficiently addressed, I think we have pretty much covered them.
Trade like or corporate. I just saw the question how
Yes.
to dress in court. My view is always dress professionally because it's the court is not going to have less trust in you if you don't come dressed as a tradie. So always be best dressed kind of thing if you can. In court, and I give that advice to all my clients if need be, because sometimes that the person will definitely be very well presented in court. So it's a matter of perception, and I just realized that, for example, in my case, I have a lot of black and white attires. It's pretty boring, but it's in a way what the court expects me to look. If I don't wear my gown and my wig, that's in general what the court expects. So yes, dress formally if you can.
Yes. Okay.
All right.
Any more questions? So I'd just like to thank you very much, Anka. It's been fascinating, and it's been very valuable because you've touched on some basic issues and explained them very well. And I think that if people are interested in this subject, then they will be able to go back and look at the video again and look for those basic concepts that you've explained, and you get a lot of guidance from it.
Yes, and if anybody has an interest of me sending the slides, just let me know and I'll make them available. Of course, they're not for distribution, and I would like not to have them on the website or anything like that because they are mine. But if you just want them for your own use, I'm happy to share them, but not to be shared further from there.
people should do that through me, so that if somebody does want them, then they should contact me, and if it's appropriate, then I will organise it with Anchor.
As long as they're not going to be dissipated from there onwards. And as I said, I'm happy for the recording to be online, but not the slides.
Yep. Okay.
All right, perfect. Thank you all for listening to me at this very late hour, and I wish you all the best with your expert reports. And I really hope that after having the presentation today, your reports would look even better than they did before.
Great. Thank you.
Thank you all. Bye.
Awesome. Thank you.
Bye.
Bye.
Thank you.